Good afternoon. Disconnect करने तो थे. Hello. Good afternoon, everyone, and sorry for the slight delay in starting today's session. My name is Mugdha Lele, and on behalf of the TechX team at Venture Center, I'm happy to host today's talk, which is part of the third wave of our Only One Team talk series on innovation management. So today is the 10th talk in this talk series, and today's topic is on investor side due diligence for IP in startups. So it's a very, very important topic, and we have a very esteemed speaker today to handle this topic for us here, Dr. Madhuri Roy, fondly called as Mani. Let me briefly introduce her before we begin the talk. So Dr. Roy is partner at Cooley from in the US, where she focuses on patent counseling and prosecution, particularly for biotechnology, pharmaceutical, and chemical companies. She focuses her practice on developing and implementing comprehensive patent portfolio strategies for these companies. This work includes patent preparation and prosecution, strategic patent counseling, and intellectual property due diligence. Madhuri has also carried out investor side and company side due diligences, FTO analysis, patentability analysis, and pre litigation work involving questions of validity and non infringement. In her 10 plus years of experience of integrative biotechnology experience to her practice, she has industry experience in mid size and large biotech companies in areas such as discovery, target validation screening, and in vivo pharmacology. She has also been involved in academic research in molecular and cellular aspects of neurodegenerative and neuropsychiatric diseases, authoring numerous scientific publications. Her academic credentials are also very, very credible, which includes a PhD from Stanford University, where her research centered on molecular and cellular aspects of gene therapy for the central nervous system. She also holds a Juris Doctor from Santa Clara University and a BA from Cornell University. Beyond her professional accomplishments, she is deeply committed to pro bono legal services, contributing to lawyers, like lawyers in the library, and supporting immigration and naturalization matters. So, Madhuri, with this brief introduction, I'm going to hand over the session to you.
Thank you, Mukta. Thank you, everybody. Really a pleasure to be here, and my second year in a row. Approximately this week. Last year I was here, and thank you for having me back again. So a couple of things. This is, I know there's people online, folks here. This is meant to be. Oh,
Yeah,
you,
yeah,
oh,
yeah.
yeah, oh, okay. Oh,
The mic.
Like that?
Yeah.
Is that nice?
So the audience online.
So I'm happy to make this interactive, questions. This is, you're all entrepreneurs and scientists and technologists and at various aspects of your development. And I'm happy to make this as practical for you. It's not an academic talk, and go from there. So Dr. Premnath and Mukta asked me to talk today about investor side due diligence and how to prepare, what you can expect. Just by show of hands, at least in the room, I can't tell online, but how many of you have been diligenced by somebody, by maybe somebody willing to give you money or a partner? Okay, so it involves preparation, it involves stress, so some of these tips some of these tips on this on the slide will help you prepare more. Which one?
Forward.
Skip on once the slides. Data. Yeah. No.
Okay, so this is just really brief. I think most of you would be are already aware why IP is important, but just to level set, level set what we're talking about, right? So IP in general, being a technology company, establishes, it does a lot of things, right? It can establish a dominant position in the marketplace. It can exclude others from practicing without a license. IP at the end of the day is like a fence on your property. It's there to protect your core asset, your core structures, but it's to keep other people out. It doesn't necessarily allow you to practice what you practice, but it's keeping other people out. It can defensively lead competitors away from the technology, and you can project it as a significant asset in some sort of financing or deal. It can invite partnerships, licensing, and establish a constant source of revenue, even if it is something you're not marketing per se. It can have other softer optical related aspects, right? As you grow, you want to recruit, you want to advertise, you want to say, hey, we're a company, we're working on these things. You from the university, come join our team. So recruiting, marketing, and the like, and can be recognition of science contributions. So as a key business asset, really where I think all of you are at, right? It has value in that having weak IP positions, especially in the life sciences and other sciences where technology is not just turning over every 2-3 years, where bench to bedside may take a decade, right? Having weak IP positions can prevent financings, can prevent or hamper, I should say, financings, acquisitions, or just have a negative impact on the valuation and economics. And so really a good IP portfolio covers your key products, actually creates real barriers to entry, and can provide ammunition versus vis-a-vis competitors. Again, this is all just sort of background, and let's get into the actual IP due diligence aspect of it. So who performs IP due diligence? Well, it can be early investors or partners, right? They're looking for the basics. What are they investing in? What is the potential? And there can be a significant variation in expectations regarding the steps. When you're early days, you may have no IP, you may just have ideas. But early investors will be looking at something in maybe seed rounds, pre-series A, and the like. As you mature, later investors and partners and acquirers, they'll want to see an IP strategy that's aligned with your business plan. So the thing that you're saying you're going to do and you're going to market or you're going to sell or provide, that your IP is mirroring that. And so they'll want to see that alignment. And then much later, perhaps the company's ready to go public on any exchange, right? I operate in the US, so in the SEC rules, but there's bank diligence, underwriter diligence. And so securities laws, not just in the US, but around the world at different markets, it's unlawful to knowingly or recklessly offer to sell a security that can be considered fraud. So at that level, underwriters may be doing diligence on what you say you have and what you say your IP protects. Again, why is IP due diligence performed? It's really to help investors and partners and eventually underwriters assess overall IP risk. Significant issues may lead to failed financings or changes in valuation and economics. And in the context of maybe a licensing partner or a big pharma or a big MNC kind of deal, they really want to understand what is the value of your IP and is it complementary to why they're interested in you in the first place. Little bit more about when it's performed, all these different kinds of contexts, most of which we just, I've already talked about. What is?
Speak to a little bit of the last for the underwriting.
Absolutely.
How does that actually happen in practice, and what is the concept?
So underwriting is typically in the context of a public financing, maybe going onto public markets where your company is now selling securities, shares to the public. And an underwriter is typically a bank, a big bank, common names you may have heard, JP Morgan, Citibank, these big banks that are underwriting your offering of shares to the public market. They take on liability. They are your partner in a sense, and they would be doing the due diligence before they agree to sign up and say, yes, we will underwrite your offering for the selling of shares. IP due diligence is thrown around. I've already thrown it around about 20 times in the last 5 minutes, but really, what is it, right? Obviously, it's an investigation, but it's an investigation into the accuracy of information that you are providing about your IP to investors, partners, underwriters, banks, etc. We can make all sorts of comments, right? As company founders, company owners, you may have heard these, you may have said these things. We have a very strong IP position. We have IP. We have no FTO issues. We have no patent problems. We have very broad claims. We have both offensive and defensive strategies. We are first in time. We have a first in class product, and our IP was filed first. We have broader IP than competitor X, right? These are statements you may make. These are statements that are investigated during the course of due diligence with the tools that are given. And I'm an IP person, so I'm very IP centric, but typically IP due diligence is done in the context of a larger diligence, right? There'll be technical diligence, financial due diligence, the looking at who is on your management team, who are your founders, what are your relationships, right? IP due diligence is one aspect of this, and typically you wouldn't be defending your IP due diligence till at least technical due diligence is done or in conjunction with, right? But that just understand that it's part of a broader landscape. And obviously, the earlier you are in your company's life cycle, there may be less of all of that to do, less financial diligence, right? It might be just IP. It might be your core team, your technology, the technical diligence, and the IP. What can you expect, right? So typically, this is what we do when we're doing diligence on a target. You might get form diligence checklists and follow-up questions that really drive the value proposition. They will ask you for all copies of registrations, applications, related materials. They'll want to really understand your product. And so by the time you're being diligent, IP due diligence is being done on you, you can't actually hold back. You can't say, oh, I'm not going to give you the structure, or I'm not going to give you the sequence or the polymer percent composition, because the other side actually needs that information to do their work, right? If you feel like there are risks with providing all of this information because the people doing diligence on you are a potential competitor, there are things you can do to safeguard this information. We want a lawyer's only call. We will, our lawyers, or we will only present this to your lawyers, but we don't want our formulation being given to you, or we'll do this, we'll only give you the ranges of a lead, or there are things you can do to hedge that risk. But obviously none of this should be given unless you're under confidentiality. But IP due diligence, you don't get there for the most part unless you've already shared your technical due diligence. Presumably you're already under an expectation of confidentiality. So be smart, but don't hijack the process. So when I say be smart, don't give all the information without being prompted and asked, but you can also hold back, right? So again, context specific, especially if you're being diligenced by a strategic. And control the information. You don't necessarily have to give copies of everything. Some of this can be done verbally, but presumably you'll be working with advisors here at the center or your IP lawyers, and they should be able to advise you accordingly. Also copies of any IP agreements and licenses, because all of that is going to be diligenced as well. You may say, well, why is that agreement important for my IP due diligence? It has nothing to do with my patents, but maybe you have an agreement where any new improvements to a collaboration is owned by the other party and not you. Well, that kind of impacts the IP that you're, the IP that you're building. So often looking at agreements and licensing is bundled into that diligence. And then any information regarding disputes and oppositions, any friendly, unfriendly letters you may have received from a third party. This is not the time to hold back, but seek advice if your alarm bells are ringing. Companies eventually will need to make representations and warranties that it owns the specific license, the IP, or that it says it owns, or that it's licensed, and that it's valid and enforceable, and that no third party is infringing the IP. And those kind of things are mechanical in nature, but eventually there'll be some sort of agreement with your investor, maybe a stock purchasing agreement, a licensing agreement, some agreement in which you will have to make those representations and any exceptions to those. How long does IP due diligence last? This can really vary. As a lawyer, I've been asked to do diligence in like less than a week. I've also been involved in diligences that can just spread out over days and months. So it's really, I would say, buckle in, but be responsive. Do not be deceptive, and disclose important IP risks upfront. I would say an average is about 2 to 3 weeks, about a month, depending on the size of the portfolio. Coming back to what investors are looking for, right? So if you think about IP, right? I think about it as different people have different pictorial representations. I think about it as a three-legged stool, right? So one leg of that stool is your IP, your exclusivity position, how you've protected that IP. That could be either what you own or through a license, but it's your IP portfolio. The second leg of that stool is ownership and rights, right? Do you own everything you say you own? Do you have valid licenses to everything you say you license, right? That's that second leg. So the ownership piece or the rights piece. And then the third leg of that is freedom to operate. Can you freely work in the marketplace, or as soon as you start selling, are you going to get slapped in infringement suit? Are you treading on somebody else's IP? Do you have third-party problems? And in a typical due diligence, all three of those will be looked at, right? Your portfolio, your third-party issues, and ownership and inventorship. But sometimes we do this summer, for example, we did a diligence, and the investor basically said, focus only on FTO. They're going into it was a Series A, they're going into a very crowded field, just focus on FTO. They'll get something. They'll get the patents they're going to get. I know they will. They're a good team. They're working with a good IP team. They'll get it. Whether they don't have anything now, it's all provisionals, nothing's granted. I'm not worried about that. Focus only on FTO. So sometimes what's being done to you is dictated by who's investing in you. So you may not, all three legs of those stools may not be explored. So it's very context dependent. But if you think about what are the investors looking for, they're looking at the strength of that first leg, the strength of your patent portfolio, that other leg about, are you infringing any third-party patents, and do you have any ownership, inventorship kind of licensing issues that would risk your own IP? Yes.
So when you're doing this 1 minute, Sorry.
Or I can repeat the question. Yeah.
When you're doing this form of a discovery process, is there a way to document the entire discovery process to give yourself coverage of the narrative so that the investor will not come back to you and say more that he thought that they got profit. Document the entire discovery process. Is there a way to?
So the question from the audience is there a way to document this process so you know what's been done? So you're asking from the company perspective, right? That you're being diligenced by a third party and
I'm asking from the viewpoint of someone who's performing the diligence. How do I know that the client has been forthright and wanted to access to everything that is there? So the discovery itself or the discovery process, how do you document that to save yourself as someone who is performing due diligence to save yourself from liability?
so did you get everything you were supposed to get and there was nothing hidden because later tomorrow if there's a problem, you should have known. You should have known that they have this FTO problem.
Let's see the three parties here. One is the startup.
Mhm.
The three parties here. One is the startup, one is the investor,
Mhm.
then there's the attorney.
Mhm.
You're talking in the attorney's perspective, attorney's perspective.
So there's two attorneys, usually actually four parties, right? There's the attorney that's representing the investor, and then there's the attorney that's representing the
You're talking about
company.
the attorney representing the investor.
Investor, right? So we have fulsome question lists that we ask, right? And I'm happy to share an example of like what that list looks like, right? I have one that's four sections and 2 pages long, and sometimes that scares early investors. So I have one that's like condensed and it's like this big, right? But it's all asking the same questions, and we often we have a what's called, so now this is me talking as a lawyer representing the investor, which is your question. So we'll have what's called a kickoff call, an introductory call. So I'll be present, my client who's the investor will be present, the company will be present, and the company's lawyer usually, if they have one, will be present. So I want to make sure that in front of my client, I'm asking all of the thorough questions. And if the company or the company's lawyer is stonewalling me or saying, oh, I can't answer that, or I can't answer that, I need my client to hear that we asked all the fulsome questions. And then we debrief with them and say, look, we asked these questions. This is what we have. We haven't gotten the structure of the lead. They're not giving us the unpublished applications. Our hands are tied. We can only do this. What do you want to do? Maybe the answer is this actually happens in real life, right? So the investor may say, look, let me talk to my contact there and get this going. Or maybe you're not going to get that information. The concern being on the behalf of the company that today you look at us, tomorrow you're going to look at our competitor, and the day after you're going to look at another competitor. You guys are also leaky. You share our confidential information, right? So there are ways to address that, but we document what we've gotten. We keep, as investor counsel, we keep notes as to what we've done. We usually provide a presentation to our investor. Company's not there anymore, right? Saying, this is what you asked us to do. Like, you asked us to not concentrate on ownership and inventorship. You said just focus on FTO. That's all we did. So later they can come back and say, oh, their patent is really not good. Why didn't you tell us that? You didn't ask us to look at that. So yes, we document all of that. And if there are problems from the company side or the company's attorney side where we're just not getting access to the information we need, we make sure that's documented. It's a good question, and I think it's like with everything, these are all very best case scenario kind of discussions, but in real life you have human nature, you have difficult people, and you have real world concerns as to why they don't want to share that information. so, going back to what are they looking for? Let's talk about the strength of your patent portfolio. So these are questions, right? That as an investor counsel, I'll be looking at, right? So we have this kickoff call where the company tells us this is our product, this is the pipeline product, this is the structure, this is the sequence. And so then we go off and we start doing the diligence, right? So I want to see, does the patents, the IP you have actually cover your key products? Those products that you told me are your key products, do the patents cover them? How much protection is provided? And that much is qualitative, right? It could be the scope of the claims. Let's start there, right? The scope of the claims, is it just covering the product and no space around the product? Is it covering a fairly good genus with specific coverage for the product? Is it covering the genus but not actually the product, because your particular species, your molecule, your composite, your polymer is actually not described in that application, right? How much is protected? Ideally, in a patent application, you see the genus, the subgenus, and the species level all protected in this sort of like in a vertical layered protection, but that's not always the case. And although I'm talking about it as it's like one application, it could be multiple patent families that provide complementary coverage to together give you protection. Maybe you have a two-part kind of product. You have an LNP, a lipid nanoparticle, that's then targeted with an antibody. So maybe one patent family gives you protection for the lipid nanoparticle. Another patent family gives you protection for the specific antibody that's being used for targeting, right? So that's a different way to look at protection. Is there varying scope of claims? Are your claims so broad that they would be susceptible to a validity challenge? Are they so narrow that, yes, they cover your product, but could be designed around? Or are they so narrow, but that's okay because it's such a crowded field that if somebody were to design around your specific narrow thing, they'd run into some other IP? That's part of the diligence. We don't do it in a vacuum, right? We try to understand the context of how crowded is this space. And when we have that kickoff call, that first call that I mentioned, we will ask those questions, right? Not just what is your product, what is the structure, sequence, whatever, what are the specifics, but who are your competitors? What is the closest prior art that you're aware of? So we can try to understand some of it. Have you done patentability searches? Can you give us the results of those so we can understand that space? Another question we look at, like, is it easy to prove infringement? Again, remember, having patent claims granted or pending and granted is to keep other people out, or to ask that they take a license to your IP. If your claims are such that, we're seeing this a lot in the computational space, or you do X and then you do Y and then you manipulate it like this and then you do this, right? How do you know that a third party is actually practicing each step of that claim without actually going into their computer or their lab or their notebook? How do you know? How do you even know that they're infringing and they need a license? So we look at the nature of the claims. There are ways to know, right? Maybe they've published something on their process and you can get a pretty good idea. Different countries have different levels of what we call discovery in litigation. But in the US, if you have a sufficient nexus, like they published a paper and they talked generally about these steps they use in their manufacturing protocol, and that seems like there's a nexus to your claims, that would be potentially sufficient for a court to give you, for a judge to give you rights to go do discovery in their lab, in their computers. Other countries are not so, it's not so easy to get discovery. US is pretty broad, but that's something we would look at in investor side due diligence. Yeah, these claims are great, they cover your stuff, but how would you actually know that a third party is practicing those claims? of course, when do these patents expire? It's 2025 now. Your patents are expiring in 2028, and you are not going to commercialize until November of 2027. It's not really providing you as much coverage as if, say, your patents were expiring in 2040. So what's the plan? What is the plan to continue to build exclusivity for your portfolio? Maybe you haven't filed on it yet, but what's the plan? So that's another thing. I mean, investors want to know that they are investing into something that is protectable. How widely have you filed, right? This is again, how much protection do you have? Like, you're sitting in India, maybe you're an India based company, maybe you're an India subsidiary, maybe you have a partner or a parent in some other country, but where all in the world have you filed? And investors understand your startups, that you don't have the funds to file in India and US and Japan and Korea and Mexico and Canada and Australia, but some core geographies probably these days. If you're an India-based company, if it is a composition of matter, India, China, Japan, US, Europe, you should get advice, but that's typically what that span will be looked at. And from an investor's perspective, is very similar to when you say have a PCT that's going to nationalize, and let's imagine you have cash, right? And you can make this ideal decision. Where all should I file in this world? Often I understand it's cash driven, and you're like, we can only file in India and Europe and US, and that's it. But say you had the cash and you ask your attorney, where else should we file? So typically we file where you plan to do business, file where you think your competitors are going to be doing business, file where maybe your investors are sitting, because they may want to see that you have the potential to enforce in the jurisdiction important to them. File where, to the extent you have a therapeutic or some sort of medical related, if there's a particular patient population. So it might be some obscure country, maybe Eurasia, but there's a genetic predisposition to a particular disease that there might actually be a need there. That goes to where you might be doing business. We're seeing companies file in parts of in countries that were always thought to be a little bit more obscure, but UAE and Qatar and Jordan, because of medical tourism. Maybe your technology is amenable to people flying somewhere to go do their product. So we would look at how widely the company is filed. Is there any possibility of additional term or extension in the US, Europe, Japan, China? I don't think India yet. You can get additional term or extension based on delays at the patent office or delays under regulatory review. So that adds to when your patents expire. And then we would look at the validity of the patents. Again, are these claims so broad that they would be susceptible to a validity challenge, either because they're so broad and they're not enabled, or they're so broad and there's prior art, those kind of questions. We would look at file histories, and this is for your issued patents. For your pending applications, it's a little bit more of a crystal ball, right? Nothing's granted yet. So we're looking at what's pending, whatever stage it's at, and trying to understand what's the strength of this. As you probably all have experienced or would agree, that often pending applications have claims, especially early part of prosecution, that are pretty broad, probably broader than what you might get granted, right? So when we do the analysis as investor counsel on pending applications, we look at the claims. Are they patentable? Do they cover the product? How much protection is provided? Again, like narrow claims, broad claims. Again, how widely has the applications been filed? And how likely is it that this claim as pending will mature into a granted claim that is meaningful for your product? And to do that, we would look at some patentability aspects. What's the prior art? Is there any patent eligibility issues? How good is the patent application as written? is it enabled? Is it clear? Is it a sufficient description? In some technologies, there could be value to having that patent grant before you actually commercialize, right? So timing may be important. Again, is it easy to prove infringement without discovery? We talked about that. What is the expiration? We would also, depending on the complexity of the case, we might do a prosecution history review. We may look at what you said, then what did the patent say? And I'm sorry, I'm not an India trained lawyer. I don't know about estoppel in India, but in the US, if you've made certain statements on record during the prosecution of your application, those can then be used in a later litigation to interpret your claims, potentially narrow your claims. So you want to look at file histories to see if their statements have been made that could later come back and limit your interpretation of the claim. On its face, the claim may look really broad, but you said things in prosecution that would actually limit it. That's called claim construction. EP, on the other hand, doesn't actually have meaningful estoppel. You can kind of say what you want in prosecution and then say something else in litigation, and there's not a connect. But in the US, it's really connected. So best, and there's case law in the US, you could have said something in your Indian prosecution or your EP prosecution, and that can be introduced in the US to limit your claims. It's not just US prosecution. So we kind of take a worldwide strategy to look at that. Are the claim, or do the claims need any correction? Do we need to get a certificate of correction? Did the examiner make comments when they were allowing the case? Sometimes they say stuff, they'll be like, I'm allowing this case because the closest prior art is X, and you've overcome that prior art. And great, I'm glad the examiner is allowing the case, but actually what they said was wrong, and it's potentially problematic because later a litigator might hold on to that. And so sometimes we try to, if we've seen reasons for allowance, we may recommend that you make a statement on a statement of candor to say, thank you, examiner, for allowing these claims and providing your rationale. We believe the rationale is actually more robust than that, and then that statement goes into the patent office record. India doesn't have this, but terminal disclaimers are ways to disclaim parts of your patent term between patent families if they're just obvious variants of each other, but it reduces terms. So even though the 20 years might take you out to 2040, if you filed a terminal disclaimer, you may have shaved off some years. So that goes into, we look at these prosecution histories. Has there been there's this duty of disclosure of references in the US, in Israel, and then in other jurisdictions in India and elsewhere upon request. And have you disclosed all of those references? Have you satisfied that duty? Has there been any inequitable conduct, fake data, suppression of information, and references? Common mistakes we see when we do diligence, that disclosure or even sale was made prior to filing. Those can be bars to patent, that those are prior art activities. Filing a patent application before the idea is ripe, so it's very broad, very prophetic, not enabled, not well described. Not putting enough detail in the application, it's just too high level. Putting too much detail in the application, you're probably giving away protectable trade secrets or know-how that really isn't advancing the purpose of that patent application, but you're giving away to your competitors information that you might have wanted to hold close. You could have otherwise held close. Not disclosing enough detail with respect to alternative uses. So describing your embodiments, but not really kind of exploring the lateral applications this is the, in some embodiments, it could be used for this, it could be used for that. So really working with your IP attorney to think about alternative uses that may not be the thing you plan to commercialize and pursue, but that for which there would be an obvious application. Waiting too long to begin the non-provisional application process. Again, maybe you have already started to sell, or you've given talks and lectures in a public forum, created prior art, or your competitors got to the patent office work first, right? So you've been sitting on it, and a competitor has IP, and then they become prior art. Not making claims count. It's like just a lot of garbagey claims. And then you have some jurisdictions like India and Brazil that are very strict. Like, you cannot introduce new claims from the specification after a certain point, whereas in other jurisdictions, US, EP, Japan, you can keep filing you can do what's called mining the case. You can pull information from any corner of the case and write claims. And not giving enough thought to foreign filing strategies. Again, we talked about why and where you might want to file. Ownership, right? We talked a little bit about this as being one of the important tools. Does a company own all the IP, or are there valid licenses to which they get the rights to the IP? Were there any inventorship issues? As a part of diligence, we typically review all relevant assignments and licenses. It's probably good for you to do that clean house before diligence starts. Make sure you obtain missing assignments, record them. Think about who all is involved with the IP: universities, consultants, previous employer relationships. Are one of your company advisors a trusted advisor, an inventor on the application, but at the same time that person is a professor at a university? Does that university then have a co-ownership right? Or somebody who's a consultant is helping you, but that consultant actually works for some big multinational corporation, and you did not have a assignment agreement with that consultant. So these are things to look at before you get into IP due diligence. Go through the histories of your consultants and all your collaborators and potential inventors. So we, as investor counsel, will always want to ensure that the chain of title is clean, right? And we look at all of these things. I think this is just the other side of the coin in terms of common mistakes, right? This is a little different in India. In the US, employees, it's a work for hire system. Ownership vests in the employee, not the employer, even though the employee is employed by the employer. That's different in other countries, in Asian countries, but we like to have employees sign IP assignments prior to employment, and then of course consultants prior to consulting consider, these are things that I just outlined, right? Recordation, not considering employment, and taking design suggestions or improvement suggestions from individuals who have no obligation to assign to you, and may not even be able to assign to you because they have a pre-existing obligation. And then playing games. This happens when how will they ever know? I'm a university professor, but I will help you on this. My university will never know. Like that, these are knowable and findable and traceable. They may not come up right away in diligence, but don't play those games. It just, you're building an asset, you're building a company. It's better that that university has co-ownership and you get a license from the university to their rights well before your valuation is high. Just clean it up early on. That would be our advice. Freedom to operate, our third leg, right? That is, do you have freedom to operate in the marketplace, or is there a risk of third-party infringement? So we would ask, as investor counsel, we would ask about previous searching and analysis. What has been done? What is the product? If the product is a small molecule, Have you done keyword searches? Have you done structure searches? Have you identified your closest competitors and maybe done assignee searches, patent owner searches? What searching has been done? When was it done? How many jurisdictions were looked at? Was just India and Europe looked at, or was it a worldwide search, right? How often do you repeat that search? Were any problematic patents or applications identified? What's your position on them? If you actually have identified a granted patent that you're infringing, what's the plan? Do you plan to approach them for a license? Do you plan to launch some sort of attack? Do you want to do nothing and wait until they serve you notice? What are the positions? These are questions that we would ask to understand what the thinking is, and of course we would have our own input for our investor client. If in the process of an FTO you've identified potentially problematic patent applications that are pending that would cover you if granted but are not granted yet, what's the likelihood that they will issue? Are you monitoring and tracking? What's your plan? Sometimes the answer might be it's pending and it's so broad, they're never going to get these claims. Here's the prior art, why we think they're not going to get the claims, or they haven't enabled the breadth of their claims. That's a position. If going back to the infringement, if you've identified a third-party patent and you have a actual infringement problem, we know they give exclusive licenses to non-exclusive licenses to anybody who asks, because it's platform in nature. We're not ready to ask them for one yet, but we will when we know that they've given, and here are the terms. We have some competitive knowledge, or you know what? We think that if this is a problem for us, it's also a problem for this other big company. So we are just going to hang on to their coattails and let them fight the fight, because there's no way that big company is going to be able to commercialize their product without dealing with this patent. And if they're moving ahead to commercialization, they must have a position. Maybe it's an invalidity position, right? So you can start to formulate positions, but you will be asked, especially as you progress through diligence, maybe not at seed round, maybe not at bridge round, but eventually as you're getting closer to commercialization, these are very real things an investor it would impact valuation, because they don't want to sign up for a risk. They don't want to sign up for a lawsuit. So these are not academic questions, is my point. Yep.
So as an investor counsel, supposing you find there's something hanky-panky and that's a negative report, how often are you liable from the startup's point of view for turning in a negative report? Like, are there any real cases where startups get upset and they see that we don't agree, or we don't see eye to eye on this issue and shouldn't have done this report? So I'm just wondering, because you're an investors counsel, how much of this is an interactive thing with the startup as well? Are there inputs taken into purview, or is it simply just based on documentation? What do you see?
So the question is around how much liability as investor counsel do you have to the company? So you have none, right? We have asked as investor counsel, we have asked all of the questions, and we've made a recommendation to our client, who's the investor. Now the investor does we don't control the investor, right? They've asked us to do an analysis. We've given them, we will never say do not invest. We will just say, here are the risks A, B, and C, and then they have to take that into account. They may come back and ask us questions. And if the investor decides that the IP risk is too high and they walk away, yes, the company is upset, but there's no liability. There's no thread between investor counsel and the company. We had a situation literally 2-3 weeks ago during the New Year's weekends, those 2 weekends bridging the holidays, where we were being diligenced, and our company is aware of a patent that is granted in the US, Europe, and China. It was opposed in Europe and it fell. It's granted in US and China. It's a problem. And we have positions, we have a plan. We believe we have an invalidity position, we have a prior art position, and we already know it's been opposed. But nonetheless, the other side, the investor council said the IP risk is too high. And we're like, how, we're as company counsel and as company, they're ready to walk away. So our CEO, our client CEO contacted, so this wasn't an investor, it was a strategic partnership, contacted their contact and said, hey, give us another chance to really explain to your IP counsel what the plan is, and we'll bring a litigator to this meeting as well. So we kind of got a second bite at the apple, if you will, right? But that's all you can do. You can't hold that investor counsel. You can kind of beg and plead and say, please give us another chance. Let us explain to you. And in that first call, they didn't have their IP counsel on. It was the business people. It just felt too scary. There was an IP risk. US it's granted, China it's granted. We can't do business in these countries. And we said, bring your IP counsel. Let's have a IP. It was a very odd situation why they would have us there, but their IP counsel not present. Their whole board was there. It was, so, but you're asking for real world examples. These are like real world examples that happen. And then our CEO was able to ask for a second meeting, and the other side brought an IP litigator and a patent prosecutor to, then we are talking the same language, like here's the issue, here's the case law. We're still waiting for their decision on that. So it might still be a big fat no, we don't know, but these things happen. And but to your point, there's no liability. Company can get upset. Our company client was upset. They felt like their position wasn't validated, and we got a second chance, but it might be you don't get that second chance. Sometimes investors may be looking for a reason, like they're looking at 3 different investments. They may be looking for a reason to just knock one off the list, right? I can see that happening as well.
Can I ask another question? Basically, there are many situations where a startup is asked to give assurances for freedom to operate, right? What is the best practice over there? They may not have done that analysis. That's one situation.
Yeah.
Or if they have done it, they, may not be confident about it, right? So, what should be the position in such circumstances for startups?
Yeah, I mean, that's tricky, right? So if they've done it, if they've not done a freedom to operate, and the other side the investor side is asking for assurances, like even just verbal assurances, at that point, we would, from the company side, I mean, it's never a great idea to go into this kind of diligence without having done something, but it happens from time to time. You can say, like, look, we have publicly talked about what we're doing. Nobody has sent us any offers to license. We have not been sent any notice letters. We have not done FTO, but we have looked at every prior art reference that has been cited in our prosecution, and none of those are an FTO problem. And we're trying to raise money so we can do these things, right? We're trying to raise this war chest so we can actually do these things. So it's a burden shift, right? So then the investor has to decide, well, are they going to walk away because this company hasn't done FTO? Because even if they give assurances, what is it based on? It's really based on these like real slim efforts. Or the investor has to say, okay, I commission doing some FTO work, or you know what, we're going to walk away and come talk to us. You're too early. Come talk to us in a couple of years. If they have done some FTO and they found a patent, that's problematic. And they want some qualifications. they can do what's called a knowledge qualification, right? So the company can say, to the best, well, actually, I'll give two scenarios. They've done an FTO, they haven't found any problems, but no FTO is perfect, right? That it's always limited by particular keywords or jurisdictions or dates or whatever it is. So you give a knowledge-based qualification. To the best of our knowledge, we do not believe we're infringing any third-party patents or applications. So it's what's called a knowledge qualification. Maybe you've done an FTO and you found a patent that's a problem, but then you've reviewed the patent and there's so much prior art that it's crazy that this patent was even allowed to be granted. It shouldn't have been granted. And if it is challenged, it will most likely be found invalid. One thing we do in representations is in this, like a stock purchase agreement, there'll be written representations. To the best of our knowledge, we do not believe we are infringing any valid IP. So we're putting that adjective, valid IP. So we're knowledge qualifying that we don't believe we're infringing anything that's valid, because our position is that it's invalid. The other way to do that is to actually disclose the patent and say, except for this patent, we have no FTO problems. People do that. That's not the best recommended course of action, because then you might be found for willful infringement. You have knowledge. But I think back to your question, how can startups deal with it? I think if they've done no FTO or they're not very confident or it's a very slim FTO, they have to burden shift that back to the investor. Investors have to understand who they're investing in. It's a company coming out of an incubator that's been strapped for cash. They can't expect that they would do the same kind of FTO Sun or Pfizer or Merck would do. Yeah.
Sorry? Is it on FTUs? You're not done yet, right?
No, I'm any.
Okay. Just one other question on FTOs. FTOs are done on primarily your know-how, right? Whether it is the body, whatever processes you're following, whether it is patented or not, you just need to ensure that nobody's going to sue you for it. So, which basically means that there will be trade secrets in that process of know-how as well, right? Now, when an investor is asking you to sort of either, do an FTO, or they want to do an FTO, you have to disclose the entire know-how, right? With and without trade secrets, right? So how do people handle that? Because if it's a published patent, you can just hand over the patent and say, this is the patent protecting this part of the know-how, right? And you can check for yourself and satisfy yourself. But what do you do when you have elements of the know-how which are trade secrets?
Yeah, so if it's a structure or sequence or a composite, then that's easy. You just give that over. That's tricky, right? Because I'm trying to think of an example. Like you're making some material and you have to heat it at this temperature for at least 20, but not more than 40 minutes. And that's actually the key ingredient to the success of your manufacturing. I think you have to provide that information. It comes back to disclosure, right? Like, I don't see how you can not provide that information. And if you are concerned about that information, again, back to what I was saying, you can say, I will not just give it to everybody on your investment team. I will give it to your lawyer. Like I will. And so I'll give whatever your IP lawyer needs, so that IP lawyer can go do the search and then report the results to you, right? Especially if it's a strategic, because if you're probably VCs and investors in 1 year out the other, right? But if it's a strategic and they're like, 20 to 40 minutes, that's how we can, right? That could potentially be a real issue. I think you have to understand do they need that information for the search, right? If you're not filing on it, are other people filing on it, right? Is that really the best FTO search? Maybe you push back. You've searched our sequence, you've searched our structure, you've searched all the competitors, assignees, and do you really need this information? We don't think anybody's, you can push back, but I think there's some amount of protections you have to take, but I don't think you can say, we're not going to give you that information.
Suppose you decide that you just let the IP council ask specific questions and respond to it and not volunteer unnecessary
Yeah.
information.
Right.
Is that considered a breach?
So,
Because
so
you may not realize if you want to ask me the question that it has to be 20 to 40 minutes, right? Or whatever it is. Or
yeah,
50.
yeah,
If you don't ask me, I don't tell you.
correct.
Right? But that can it come back to haunt you that you didn't disclose this to us?
So it comes back to that kickoff call, right? Like that first call where you're like literally trying to get all the information from the investor perspective, right? You create these questions, but that questions gets into discussions. We're really trying to understand, okay, what's your product? It's this composition of matter, but the composition of matter is not new. So what's actually new? Oh, it's that you heat it at this temperature when you're producing it, right? That like it's like you, as investor counsel, we're constantly thinking on our feet to ask all those intervening questions in our framework to get as much information. So we will ask general questions like, what's the hook? Like, what's the key aspect of your product? But I think from a company perspective, other than the obvious like structure and sequence and percentages and things like that, things that are know-how, I don't know that you would necessarily volunteer it, but be responsive, right? But if they didn't ask, there's only so much they can ask, right? And at the end of the day, investor side due diligence is a risk analysis. It's going to be imperfect in some aspect, one or more aspects, right? And even an FTO is not perfect. Even if you've done a very fulsome FTO and you spent crore rupees doing this FTO, it still may have some blind sides. So
one of our startups, Rohan also had a similar question whether DD includes the know-how and trade secrets. I think it does, right? To the extent that you volunteer.
Yeah.
Or you're asked.
Right.
Right.
I mean, you may get a generic question from an investor. Please tell us all your material trade secrets. And I would push back on that question, right? Like, why? Like, do you need this information for your searching? I'm happy, I wouldn't just say, oh, okay, here, like it's not in your best interest.
Yeah, sure. I'll come back to the remaining questions. You have some online.
Yeah, sure. Yeah. Just some, I don't think this is anything new, but how to prepare, look savvy and prepared, be savvy and prepared, not just look, right? Be savvy and prepared. It's like before guests come to your house, you're cleaning everything and places they may or may not look in your bathroom, right? Like that. Treat your IP portfolio like that. Like test yourself before you get tested. Be responsive, proactive, get diligence done quickly. You don't want this headache like dragging on for months and months. Understand who on your team is going to address what questions. Maybe right now you're a 4-person startup, maybe you're not a big 20-person company, but eventually, right, who's going to answer the business/market/opportunity questions? Who's going to answer the technical questions? Who's going to answer the legal questions? Somebody's helping you on IP, maybe they can answer the IP questions. Make a plan, be planned and organized. And this is just you guys will get the list of the slides, but be prepared to provide all these kinds of materials that some of them may not be relevant. And having IP counsel is like being honest with your doctor, right? Don't give like partial information and embarrassed of something so you don't say something. Just have find people that you have good relationships, that really understand your technology. You know, this more IP isn't necessarily better. Sometimes we say startups, we see startups who are not startups, companies, right? Just any size, will say, I want to file on everything, I want to file on all of this. And we say like, hey, you know, maybe some of these are not right. Just build that relationship such that they can give you feedback, and that it leads to a more meaningful portfolio. And as with any relationship, right, make sure it's not just transactional. It's not just, oh, my IP lawyer filed it and I don't have to call them till a year later till I have to convert my PCT, right? Ask about the process, you know, discuss with them the improvements in major inflection points. If you're going to go to a meeting, a conference, or a presentation, what does that presentation look like? And from a cost saving perspective, talk to your counsel about creative ways to divide tasks. You know, sometimes when I work with companies, if we're trying to keep costs minimal, I'll say like, you write all of the examples and the figures, and that will save a lot of time than us charging you to do it. But let us write the claims, because that's really, you know, sometimes people think anybody can write patent applications, and it's not really true at all. So, right, you know, have that relationship, find somebody who you can work with, because they are going to be the ones who are going to be defending you as you move up in your business dealings. Yeah, if there were other questions from, yeah.
Generally, we sign many NDAs during the course of time. Do you come across any NDA violation which was contested somewhere?
So you mean like you as a company sign an NDA with a pharma company, and they've violated that? I mean, we have seen that where you've talked about something under confidentiality, and 18 months later you see a filing that's coming out of that company. That's a breach of, I mean, not only is that a breach of confidentiality, that's a misappropriation of the information provided under confidentiality. And so, yes, we have seen that, and it's quite difficult to prove, because it's highly fact dependent, but yes, it happens. And so, and an NDA, a non-disclosure agreement or confidentiality agreement, is just a protection. It's not the end all be all. So you need to be savvy with who you're giving that information to. If you think they're talking to your competitors, or they have a competitive program in-house, you have to be defensive. Because proving that, but for that discussion you had when you disclosed this thing, and then 18 months later they showed up with a patent application, is going to take proof in court, and you may not have the funds for that, right? So it's a defensive play.
There's a question online on about even the due diligence. You spoke mainly about patents.
Yeah.
But there's a question also about what about due diligence of other IP?
Yeah.
The other issues relevant to that a startup needs to think about, and that's the issue they have asked.
Yeah, so that's a great question. So when we think about sort of important IP for a company, it's usually obviously patents. We talked about that. Trade secrets, which we've talked a little bit about. Trademarks, and maybe copyrights if it's a software kind of play. There are other IP, personality rights and things like that, but let's assume for technology companies such as yourselves and those online, it's going to be one of those four. So we've talked about,
and in India, the design
registrations, yeah.
That's one. And of course, there are others like plant varieties.
Yeah, so design registrations under patents, not utility, but design. Yes, in the US as well, right? So, but as a design patent. Design patents, so one by one, right? We talked about sort of utility patents. Design patents are, I would say, would be diligenced in a similar way, but the value of a design patent, unless you're like making an Apple iPhone or something, it depends. I shouldn't downplay the designs involved in your technologies, but we just don't see that. Maybe for some medical device companies, there's aspects of that, but is that design patent delivering the value that the investor is putting, or is it just a nice to have? And that can come out during diligence. So yes, they'll look at the design patents, but I don't think an investor is going to say, oh, they have no utility patents and all design patents. That's probably not the best position for a technology company. We talked about trade secrets and how much to disclose and what to diligence and what do they really need to know. Are they just asking for asking sake, or do they really need to know for the diligence? For trademarks, especially if you are starting to commercialize your product and you're building a brand, trademarks are going to be important. Company name. A trademark, remember, signifies not the thing, but the origin of the goods, right? So if you think you want to, as a advice to companies, if you think that you want to trademark something, make sure you don't genericize it by referring to your product by that trademark. Don't make it a noun, right? And so that can be diligenced. Copyrights, I think, like if your technology is code, like software code or computational tools, those I think will be diligenced more as trade secrets and know-how, because those are not always patented. And in those kind of situations, you may be asked to share your code or share blocks of code or do test simulations to show what it can do with their inputs. And there's different kinds of diligence. So I would probably put that more into like the technical diligence of what your code can do. Copywriting protects code, but I'm not I'm not a computer scientist or a software lawyer, but I think there's some amount of diligence that can be done, but it's more of what can your code do as much as just the code itself.
I think one of the things that may be important in especially code, but it's relevant otherwise also, which you might also want to speak about, is the kind of arrangements under which you have got access to probably an open source kind of
Yes,
right?
yes.
That's one kind of a situation where there'll be severe restrictions on what you can do following that. The other context is sometimes people have already entered into some kind of joint development agreements and so on, or they may have licensing arrangements which might be equal to some part of their claims. And how is that seen by investor council?
Yeah, so two different things. So thank you for bringing up that point. I skipped over that, right? So if you are accessing open source code, it's usually comes with restrictions. It's not negotiated restrictions. It's if you use this, it's this. And if you then improve your code using that, your code actually gets incorporated into the code. So that is often a question of, are you using any open source, and what are those restrictions, and have you actually dedicated your code into a broader ecosystem? Coming to the question you had on maybe a collaboration agreement or a joint development agreement. So part of what I said is like diligence will be done on your agreements. What kind of rights have you already given away, and if there is joint development actually happening because of collaboration, maybe you're giving something and the other side is giving something else, and what are the IP provisions around that? If there's any improvements on your molecule, do you own it, or does the other side own it? So we would look at typically IP provisions in an agreement. From an IP investor perspective, we may not be, looking at royalties and milestones and payments might be part of like a financial due diligence, like what are the liabilities that this company has. But from an IP perspective, we'd want to see like, you'll see agreements where improvements to even your molecule is owned by the other side, but you get the first right to license, right? So that starts, when you're doing a balance sheet, that starts adding more cost for eventually having to license technology. So yeah, that can be diligenced in. And asking whether, also asking whether any IP has actually come out of that agreement and what's its status.
Online. Gautam, you want to take it up? But before Gautam poses his question, alerting the online participants, the feedback link is in the chat box. Please do not leave the session without giving feedback. It helps us to incorporate new sessions and topics of interest also. Yeah, over to you, Gautam.
So thank you for this presentation. I had two questions. So we are currently in a business due diligence round right now with one of the investors, and we are also doing multiple pitches with investors in India as well as abroad. Now, one major question that keeps coming up is we are currently developing 3 more patents that's in progress. It's an R&D work that's in progress, but we know that patent is unique enough to be granted. We have done a prior art search and all of that through IIT Madras IT cell. Now, the question is, when investors ask us, hey, can you disclose something about this? How do we know that this is an actual thing that's in progress? How, up to what limit can we disclose? That's the first thing. And the second is, before going to investors and giving a pitch, I mean, is it common practice to get an NDA done? Yeah, these are the two questions here.
So maybe I'll answer your second question first. I mean, I'm sure there's variations in that, but usually for a pitch, no investor is going to sign an NDA before. That's the point of a pitch, right? So typically as a company, I think you'd want to think of having 2 slide decks ready. One is what we call a non-confidential deck, a non-con deck, which is the broad strokes of your technology, your value proposition, where you are at a company, things that, you know, maybe you're not going to put on LinkedIn, but if it were to find its way into the wrong hands, isn't going to be a poison pill for your company. So highly unlikely that for a true first pitch that the other side would sign an NDA, but if they start asking technical questions, legal questions, financial related questions, I think it's perfectly fine to say like, look, let's progress into NDA, and then progress further with an NDA. And then if they really want the information, they need to do the real diligence. Ideally, you should be on the other side of a term sheet, right? Some sort of like non-binding diligence understanding, like this is the amount we're going for, this is the term, these are the people, this is what we plan to do. So that's like the 3 steps of the dance, right? No NDA, just open discussions, NDA, term sheet. So you shouldn't be sharing any of your non-public IP information, any of that information until you're on the other side of term sheet. And so all the things I talked about proceeding with caution and everything, that's even on the other side of a term sheet. Definitely not before term sheet. So your first question, you cut in and out a little bit, but I want to make sure I understood it. You are being diligenced, you're in some stage of diligence, you have 3 patent applications you're currently working on, and you've done analyses and you're confident that they will progress well.
Yeah, but he has not filed it yet.
It's not filed yet.
Yeah, and investor say wants to know more about it.
Okay.
Right? So how does he deal with it? That's the question. But just to add a little bit your comments about the US, that's the same we would do in India, which is that progressive through those 3 stages.
Okay.
Right? But please continue with the
That's good to know. That's sort of like a first principles, if you will. Yeah. Okay. So I guess my question to you is, what ideally maybe just file it, right? Okay, let's assume that that's not possible right now, or you've made a decision to not file it. I think you, as a part of your technical diligence, if you can provide, is this investment with a strategic or investment from like just like like a general investor?
Yeah, Gautam, you may want to answer that. Is he still allowed to speak?
General, he said general. Okay, so if it was a
It's general.
strategic, I'd be more concerned that you're giving them information about your technology without actually having defensively protected it yourself. I'd be concerned with the general as well, but I guess it depends on what information they need to know, right? Like, if you're giving them things that you otherwise would file on, again, all those precautions we talked about, right? Like giving them only what they really need to know and not the whole package, right? But I think I would say proceed with caution. You're relatively unprotected, right? And if to the other gentleman's question, what if they misappropriate your relationship, and then you've given them a lot of details, and then they go off and file something themselves? You can't actually say, hey, we got to the patent office first. You could do a filing. Like, there may be a reason you don't want to file yet. It's like, hey, I don't want to file now because then it starts the 1-year clock, and in a year I don't think I'm going to be ready with all the data. That's a understandable concern, but you can still file so that you're protected, and then expressly abandon it and restart the 1-year clock. But at least you're filed from a protection perspective. That's an advice we sometimes give. If it's technology, I think that's not in your case, Gautam, but if it's technology that just can't be filed on, right? Like that happens sometimes. It's know-how or something. That's a different situation. I would proceed with a lot of caution. Your investor may also ask, well, why haven't you filed on this? Like, shouldn't you be filing on it? I think you need to have, I mean, happy to chat about it if you want now, but I think you have to have a very clear articulation as to why it's not filed on. Because at the end of the day, any risk to you is a risk to that investor if that investor decides to invest in you also. So
A question about patents. If somebody should startups, I mean, doesn't typical investor, would they want to see a granted patent? Okay, or are they okay evaluating a professional patent? I mean, or even an application which is being considered.
Yeah.
Sometimes people feel that there is a great need to accelerate the grant.
Yeah.
Right, and it has its own
Pluses and minuses. Yeah.
So, do you want to comment on that? How does the investor see application versus a granted patent?
Yeah.
In the context of the fact that some of the grants can be invalidated also.
Right. Or they're junk
Or
patents.
they're junk patents.
Yeah.
So, in that context, do you want to say how do investors look at it?
Yeah. I would say there's a wide swath. I would say general investors who are savvy, who invest in your space, and they're not first-time investors, and they're not that conservative. They understand the value of a pending application. What they want to see is those questions I asked, right? What's your strategy? Do you think you're going to get the claims you say you're going to get? What's the prior art? They want that information so their counsel can look at the patentability and say, yeah, I think they'll get a reasonable scope of claims, right? So I think that they can be comfortable without a granted patent. You can also have granted patents that are worthless, right? So just having a granted patent isn't always helpful. It might not be helpful. We see an underwriter diligence, like on the other end, like this is years from now, but you're ready to go public. Banks are pretty conservative. They're like, but they don't have a granted patent. Like, I like, what, are they going to get it? They don't understand. They don't. I think earlier VC investors were technology investors, kind of they speak this entrepreneur language. I feel like banks, they're much more buttoned up. They want to check that box. I don't understand, like they don't have a granted patent and they've been in business for 10 years. What's going on? Is their IP any good? So I feel like they want to see granted patents. Hopefully by the time you get to going on a public market, any of you have granted patents, and that's not an issue. Strategics like a pharma or some MNC investing in you, they like to see granted patents, but it's my sense it's not because they don't understand, it's because they want to actually lower your valuation. They might want to use that as a reason to lower your valuation. And so I have companies who are like, hey, we're going to, after there's this big healthcare conference going on right now, this JP Morgan healthcare conference. I was just talking to a client last week, antibody client, and they said, look, I used to work at Pfizer and I know on the BD team, I know what they look for. So let's just accelerate this and let's file a product, like a product specific patent, and then we can go back in and get the broader stuff later, because coming into JPM, I know that that's the scrutiny. I want to have at least a notice of allowance by December. This is a conversation we were having much earlier this year. So strategics, I think I think, and I don't want to blanket slam that, but like I think that there's a little bit of gamesmanship that's happening there.
There seem to be some more questions online,
Sure.
but
I think we'll just take
but we
one
need to
last
close.
one.
Last one, yeah.
So there's a question, should we share the patent details with the strategic investor before signing the NDA?
Should you share the patent application? If it's published, no problem. If it's unpublished, like a provisional application, I would say no. If they really press, maybe you say, okay, we'll give you the title and abstract, or we'll give you the title and abstract and claims. We've done that in the past, like they want the whole application, we don't want to give the application. So there's this little bit of a dance that you can do.
I think we should close now. We've well stepped over our planned time because we also have a closed door interaction with some of our startups.
Sure.
Brief one now. So thank you so much, Dr. Madhuri, for this wonderful session. And just one more announcement for all of you. The feedback link is here, so please do. It's projected on the screen here. The next session in this series will be on 11th of February, and it's a Tuesday, and this is our only one team next talk series, which is coming on 11th of February, 4 o'clock. This will be in online mode only because our series works in online mode. Today's was a special session. Since she was here in person, we did it in hybrid mode. And thank you to all of you who could join this in person. Thank you so much, and we'll close for today.
Thank you.
Let us thank her for the